Karnataka High Court needs no formal introduction in legal circles, but allow me to introduce him in a nutshell. Graduating from the prestigious law school in 1996, he quickly made his mark and earned his senior counsel robes in 2018, quite literally rising to the senior tiers of the bar. Shyam comes from a legacy of legal brilliance. I think his family tree has seen more courtrooms than branches. With his father, Justice S. Venkatraman, as a High Court judge, it's safe to say law and justice runs in his blood. And it is evident to having headed the litigation and dispute resolution practice at Indus Law, mastering the web of litigation and dispute resolution, and handling some of the most sophisticated commercial cases across trial and appellate courts. Today, Mr. Raghavan stands proudly among star individuals in the dispute resolution in the chamber and partners Asia Pacific Guide 2025, a recognition that cements his reputation as one of India's top litigators, and he does it all with ease and poise. He has been our Srimutt's trustee and legal advisor for a very long time. But what truly sets him apart? His down-to-earth attitude, unmatched humility, and respect for tradition. You'll always spot him with a calm smile, a nama on his forehead, and an aura that speaks volumes about his deep-rooted values and devotion. His family has been a long-time devoted followers of our Srimutt, a tradition he carries forward with quiet pride. Professionally, he's a rock star, a Chambers ranked senior counsel, a strategist with a brain sharper than the edge of the Supreme Court judgment. But among the students and juniors, he is also lovingly known as one of the sirs who just awesome. He got the fan following, the kind where the juniors look up to him like a celebrity, like he's the Rajnikant of the courtrooms. Let's give a big round of applause to our guest of honor, Mr. V. Srinivasa Raghavan, Shyam Mama, sir, we are so grateful to have you here today, having taken your time from the busy schedule. It's our privilege to listen to you today. The stage is all yours. Srimathe Ramanujaya Namaha.
Srimathe Ramanujaya Namaha. Pronounced to the lotus feet of His Holiness Sri Yathiraja Narayan Jeeyar Swami. Grateful to him for this opportunity to be of social service. It's really unique that this institution, this MUT, has thought of conducting these kind of programs and not merely limited to the religious aspect, but also to serve community at large. So as a part of this outreach, under the guidance of Jeeyar Swami, the MUT has started holding programs to reach out to the community to meet their needs. We have had lectures on cardiac health, Ayurveda, and in the course of this, Jeeyar Swami has thought it fit that legal awareness is also very important to be infused amongst the community. Therefore, I'm grateful to Jeeyar Swami for having given me the opportunity to use my experience and education in the legal field to be of some use to the community. This being a legal awareness program and the time being limited, I will try to give a very broad overview of certain aspects. There are about 4 aspects which we have listed. I'm not sure whether we'll be able to cover all of them. One of them is about fundamental rights and duties, which every citizen ought to be aware of. The next aspect is, what is the jurisdiction of the state in religious matters? Now that we are having this program in a religious institution, and there being a lot of discussion about state intervention or government intervention in religious affairs. Naturally, every citizen would be curious to know what is the basis for this, how is it that they are regulating, what are the rights of citizens in that regard. Then, of course, matters of inheritance and property, which every citizen would come across in their lives, about succession, about joint family property, how is, and I have come across a lot of queries, especially by senior citizens, about a will. Is it required? When is it required? How do we go about doing it? These are some of the aspects. Then, of course, consumer protection is another aspect which I will deal with. We are all consumers of goods and services, so it's important to know our rights there. Each of these subjects are huge fields in themselves. Constitutional law is enormous. So, obviously, it will not be possible to cover the nuances, and the law is so vast and keeps developing with the changing times. We come across in the newspapers information about Supreme Court judgments overruling other judgments. Just about a couple of days back, we read the news about, in an insolvency matter, how the Supreme Court recalled its own order. So these are the developments which keep taking place. So therefore, it will be difficult to cover all these aspects, even in respect of fundamental rights, in a very short time. But since this is a legal awareness program, let's go about having a broad understanding of what the Constitution speaks about. So, we all have heard of fundamental rights, but the Constitution also speaks about fundamental duties. Our ancient system has focused more on duties rather than rights. And this is rightly so, because once the citizens focus on their duties towards each other, the scope for dispute reduces. We see the same even in the family system. We are all told, and that's what we have heard in the course of the several discourses which are organized by the Mutt. Do not ask what is your right, ask what is your duty. Have you performed it? The son should ask what is duty to his parents. Have I performed my duties? The parent should ask what is my duty to my children. Have I performed them? Once the focus is on duties, the scope for dispute reduces. But unfortunately, having gone by a Western model, we have focused more on rights till now. But therefore, I thought it fit, even though the bullet point mentioned about fundamental rights, to also bring in the concept of fundamental duties. So let's just go first through the fundamental duties before we go to the rights. Abide by the Constitution and respect its ideals and institutions. Cherish and follow the noble ideals that inspired the national struggle for freedom. Uphold and protect the sovereignty, unity and integrity of India. This, I would stress at this stage, is very important, because we all focus on the right of freedom of speech and expression. But in the course of that, while we have every right of criticism, but are we also looking at the duty which we have, which is to uphold and protect the sovereignty, unity and integrity of India, defend the country and render national service when called upon, promote harmony and the spirit of common brotherhood amongst all people. Now, this is where you will find all cases of hate speech which are now coming up in the media. So, one of the fundamental duties is to promote harmony and spirit of common brotherhood. Value and preserve the rich heritage of our composite culture. Very important duty. Develop scientific temper, humanism, and the spirit of inquiry and reform. Now, the spirit of inquiry is not what is now given to us by our Constitution. In fact, the spirit of inquiry is what we have got from the ancient ages itself, right from the Mimamsas, which is nothing but an inquiry. Spirit of inquiry and reform. Safeguard public property and abjure violence. Ahimsa paramo dharma. Strive towards excellence in all spheres of individual and collective activity. Provide opportunities for education to children between 6 to 14 years. And most importantly, and which is the pressing need now, protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Exactly what our ancient philosophy has taught us. Now, these should be read along with the fundamental rights. Of course, we all know fundamental rights. In here, as a human being itself, we have some fundamental rights. This is more, the Constitution therefore more declares what is understood. There are a set of basic essential rights for every citizen to lead a fulfilling life. They ensure individual freedoms, and protect citizens from potential state overreach. The concept of fundamental rights, when it was drafted, was aimed more at protecting the citizens against actions of the government. So therefore, you would find the constitution being framed in such a way that a fundamental right is enforceable against state and its authorities. However, as the society has developed, we would find that the courts have interpreted to say fundamental rights cannot be very limited in scope to only state action. Further, we have seen governmental action reaching out in very various ways through different instrumentalities. Sometimes the government sets up societies. Societies would again then be interacting with individuals. There could be rules of the society. And therefore, in the course of it, there could be questions as to whether fundamental rights are being violated. So therefore, courts are now interpreting fundamental rights to say it is not just available against the government or the state, as we call it, but it could be against other individuals also, or corporations, as the case may be. So when the constitution was first drafted, this concept of state was something which was held as to be important. And therefore, what was a state is defined in Article 12. It includes, of course, the government and Parliament of India, government and legislature of the state, as we understand. All local or other authorities. Local authorities, we all know. It's your municipal corporations or panchayats. What are these other authorities which the Constitution refers to? Now, that has been a subject of interpretation by the Supreme Court. And the Supreme Court has held there could be various organizations in the form of, as I said, companies, corporations, societies, which need not have been formed by any statute as such. But the reach of the state or central governments could be through those organizations. In the sense, you could have a, let us say, a government company which carries on certain activities. But we all know that the government company is therefore controlled by the government. And therefore, the funding is by the government. Therefore, a state action need not be only by the government as such or the legislature or your local authorities. It could even be actions through companies or corporations. So, wherever there is administrative, functional control or pervading influence of the state over any entity, that would be also construed as another authority, and therefore the importance of it falling within the clause of other authorities is then for actions of the state or state and its instrumentalities, as they say, you could straightaway lay action in the High Court or the Supreme Court, as the case may be. Whereas for non-state authorities, any actions could be in your regular courts. So that's what makes the definition of state important, because then your enforcement of fundamental rights could be at the High Court or the Supreme Court level itself, as we see. Now, what are those fundamental rights? I will not list all the fundamental rights, but some of the most important ones. Article 14, which is right to equality. This is a very, very important article. It protects citizens against discrimination. It guarantees the fundamental right to equality by stating that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So all citizens, all persons are deemed as equal. Now you must note that Article 14 is not limited to only citizens. It is against all persons. So what is equality? Naturally, we will immediately know equals cannot be treated unequally. But there is another angle to it. There could be unequals. Unequals also cannot be treated equally. If unequals are treated equally, there would be discrimination. If we just take, for example, let's say a race. Let's say a well-bodied person is there, and then we have a person with disability. Naturally, you cannot treat them as equal and then treat them in the same way, because they are unequals in certain disabilities. Therefore, treating unequals equally is also discrimination. Therefore, unequals have to be treated unequally according to the differences which are there. That's why now Article 14, as has been interpreted by the courts, allows classification. That means grouping people differently, because naturally, once a legislation is made, the object of the legislation could be such that definitely groups may have to be made amongst different people. And therefore, such classification is accepted by the constitution, because this classification also cannot be made arbitrarily. There must be some rational basis where you can distinguish between different sets of people, and to achieve a particular object, you may need to make the differentiation and treat them separately. And therefore, this classification is also permitted under Article 14. So one cannot simply say equality, on a very broad basis. We have to understand the nuances within equality also. That therefore, treating unequals equally is also against equality. And therefore, unequals may have to be treated differently. And therefore, classification is permitted. Then Article 15 is another important article which in a way goes along with Article 14. It is one facet of equality. Prohibition of discrimination on grounds of religion, race, caste, sex, place of birth or any of them. So Article 15 clause 2 also states no citizen shall on grounds only of religion, race, caste, sex, place of birth or any of them be subject to any disability, liability, restriction or condition with regard to access to shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Then 15 clause 3 is again important. It is again a facet of equality. Nothing in this article shall prevent the state from making any special provision for women and children, because historically, considering how women were considered as let us say a subjugated class, and they were not allowed to pursue their freedoms. Now this constitution itself permits, you can make special provisions for women and children, and therefore that will not be, because if you see 15 clause 1, it would say you cannot discriminate on the ground of sex. But then 15.3 says you can make special provision for women and children. Therefore that's the exception, because they can be considered as a separate class. It is this which will have practical application, as you see, where if there are, let us say, starting with a simple thing like seats reserved for women in buses or in trains, etc. All these are allowed by the constitution because of this provision. Similarly, 15 clause 4, nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. So these are also considered as unequal people because of historical subjugation. And that's how we would find in 15 clause 5. It will not prevent the state from making any special provision for the advancement of any socially and educationally backward class of citizens or for the scheduled caste and scheduled tribes, insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than minority education institutions referred to in clause 1 of Article 30. This is how you will find the concept of reservation coming into admissions to educational institutions, because historically it has been felt these socially educationally backward classes have been deprived of the access to education, and therefore they need to be given that special push or advantage so that they can compete with the rest. So also in pursuance of this, now by way of amendment, you will find 15 clause 6, because if you see 15 clause 5 earlier, the concept was socially and educationally backward classes of citizens, which the Supreme Court interpreted to say there is an element of caste which is there, because social backwardness comes with caste, and therefore caste is an important factor in determining social and educational backwardness of citizens. But then it was felt that this special provision should not be limited only to this section of people, because there are vast sections of the population who are economically backward, and therefore some provision should be made for them. That is how, by way of an amendment, you find that the state is now allowed to make special provision for the advancement of economically weaker sections of citizens other than the class mentioned in clause 4 and 5. That's how you find this EWS quota, as what you have popularly heard as EWS quota. Other than SC, ST and OBC, you have heard of EWS quota. So this is how this EWS quota comes into picture. So if you see clause B, any special provision for the advancement of any economically weaker section of citizens other than the classes mentioned in clause 4 and 5, insofar as special provisions relate to their admission to educational institutions, including private educational institutions, Again, going to the end of the article, subject a maximum of 10% of the total seats. So therefore, you would find the concept of 10% for EWS category, which is now being brought in by way of this amendment to the constitution. As you all know, there is power to amend the constitution itself. But the question arose whether to what extent does this power of the parliament go? Can it virtually change the whole of the constitution? If the power of amendment is there, that means it can amend each and every part of the constitution, the whole of the constitution can change it. So that is how you find in the famous judgment of Keshavananda Bharati, the Supreme Court came out with the concept of something called as a basic structure, saying yes, you can amend parts of the constitution, you can amend provisions, but you cannot tamper with the basic structure. There is something called as a basic structure, which is so basic, even the parliament, which is a creature of the constitution, should not be entitled to efface the structure itself. And therefore, this concept of basic structure was evolved by the courts. You don't find this in the constitution itself, but by interpretation. When the question arose as to whether the parliament could amend every aspect of the constitution, the Supreme Court said, no, there is something that can be implied, that basic structure should not be amended. For example, if one were to say that the parliament can amend any part of the constitution, even some of these fundamental rights which are there could be totally taken out by way of an amendment. Could that have been the intent of the makers of the constitution? That was the question which was posed. Obviously, the intent of the makers of the constitution could not have been to give such a vast power to a body created by the constitution itself to virtually take away all the fundamental rights, and therefore this concept of basic structure was evolved. What is basic structure? Again, there cannot be a simple answer. You may have to go on a case-to-case basis. Whenever the amendment arises, Supreme Court says, yes, we'll have to consider now what is the basic structure. For example, the concept of federalism is considered as a basic structure. Parliamentary democracy is considered as basic structure. Independence of the judiciary is considered as a basic structure. That is how you would find when the National Judicial Appointment Commission amendment was made to the constitution to try to bring back the role of the executive in the appointment of judges. The Supreme Court struck it down saying, no, you are now tampering with the basic structure. The independence of the judiciary will be affected if this amendment is allowed, and therefore you cannot amend this part of the constitution in this manner. So similarly, when this article on 15(6) to bring in EWS category was brought in, that was also questioned before the Supreme Court, whether this amends the basic structure itself. The Supreme Court then said, no, this does not affect the basic structure. The object of the constitution is that when there are unequals, they have to be treated unequally, they can't be treated equally, and therefore, though the original constitution provided for a treatment of scheduled caste and scheduled tribes differently, that did not put a fetter if it was felt that there is another section of people also who need to be given special provisions. There was no bar against it, and therefore, if the parliament has thought it fit to amend the constitution to make special provisions for the economically weaker sections of society, irrespective of the caste, then in such a case, that is not against the basic structure. That is also treating unequals unequally, and therefore that is not offending the constitution. Now, along with Article 15, we'll have to be read Article 16. Article 15, as you saw, clause 4 and 5 dealt with education. Article 16 deals with public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall on grounds only of religion, race, caste, sex, descent, place of birth, residence or any of them be ineligible for or discriminated against in respect of any employment or office under the state. Then you will find similar provisions in clause 4, 4a, and thereafter again by way of an amendment insofar as economically weaker sections and scheduled caste, scheduled tribes and the other backward classes. Now, one of the questions which arose, and you would also be curious, from where do we get this 50%? We always heard something about 50% reservation as the cap. Where do we get this 50%? It's not mentioned in 15 and 16. So this cap of 50% was evolved again by courts in the course of interpretation. The question was, can reservations be made to such an extent that there is no provision at all for general merit, or it is so reduced that people from other castes do not get a right or opportunity at all to either get admission into educational institutions or to even get employment in public offices. That's when the Supreme Court tried to balance it out and say, no special provision can be made. At the same time, merit cannot be compromised. So we find that up to 50% is a good way of balancing both, where you can make reservations up to 50% and then there is opportunity for all beyond that. So this 50% is a balancing act. But is that 50% a inviolable rule? The Supreme Court itself said in the decision in Indra Sahni's case, a 9-judge bench judgment of the Supreme Court, that there could be perhaps, for example, we hear of extremely backward areas, or let us say hilly regions or a tribal belt where majority of the population is socially and educationally backward. In such cases, the government may make an exception and go beyond, but that's an exception. Normally, it should not go beyond 50% was what was considered there. Now, when this provision of EWS reservation was brought in and which added 10%, so then the question arose, is this not violating the same 50% rule which the Supreme Court had laid down? And therefore, now could it be that reservation could go to an extent of 60% by virtue of this? So that was also upheld by the Supreme Court to say that 50% was a norm which was laid down. It provided for exceptions, and this is one kind of an exception which is made, and therefore this again does not go against the concept of merit. Now, of late, the Supreme Court in a couple of judgments has taken the view, we should first question what is the concept of merit. Is it mere marks in an exam? Why do we always think that only a person who scores more marks in an exam is considered as meritorious? It need not be. One needs to look at the social, educational background, the community from which a person arises. After all, people then go back and serve that community. Therefore, one should look at different factors than mere marking as a scale of merit. And therefore, the Supreme Court felt there is nothing wrong in making this reservation up to an extent of 10% for these economically weaker sections. So this is where from 15 and 16 is where we get the concept of equality in educational institutions as well as in employment. Then Article 19 is another very important article. Yes. So this article says that all citizens will have the right of freedom of speech and expression, to assemble peaceably without arms, to form associations or unions or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of territory of India, to practice any profession or to carry on any occupation, trade or business. So these are some of the fundamental rights which naturally any person in his life would want to have. A right to speech and expression, to right to move around, to carry on his own vocation, whatever he wants, to earn his livelihood, to assemble, to protest. So these are all contained within these articles. But are these freedoms absolute? They are not. Naturally, every freedom comes with responsibilities, and therefore every freedom can be subject to reasonable restrictions. So we then see Article 19(2), which sets out there could be reasonable restrictions on freedom of speech and expression. Nothing shall prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred with said subclause in the interests of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality in relation to contempt of court, defamation or incitement to an offense. So these are all laid out in the Constitution itself as exceptions, in the sense the state can make law and curb your freedom of speech and expression to achieve these objects. That's where from sovereignty and integrity of India, security of the state, you will get all these laws regarding sedition, which would have come across a lot of discussion in the papers. Laws which make sedition as an offense. Where do we trace it back? So that speech which leads to overthrow of a properly elected government, or armed insurrection, as they say, to overthrow the government and to cede from the territories of India, these are all acts of sedition, which the state is entitled to say, we will not allow you the freedom of speech and expression if it goes to the extent of affecting the sovereignty and integrity of India. Now, when you come to public order, this is where you will find all the hate speech cases coming up, that once you give a speech which tends to incite people to start hating and then carry out acts of violence, then that is something which will affect the freedom of the other person. And therefore, the state is entitled to make law to restrict your speech as long as it is affecting public order. Now, decency or morality, this is where you will come across all your laws on obscenity, pornography, all your outraging the modesty of women, all these sections can be traced to this. Your expression or freedom of speech cannot go to the extent where decency or morality is infringed. Now, contempt of court also comes into this. People will think, well, if this is a sword being held against freedom of speech, why should we not speak against the courts? We should all understand that respect towards court decisions and court's orders is very important for an orderly society. Otherwise, if people hold court orders in contempt, then they will not obey them. And ultimately, that has a bearing on the very freedom of the individuals. Therefore, in the interest of individual freedoms itself, these restrictions are placed, saying if you start speaking in a way that holds the court in contempt, there is no difficulty in criticizing court orders. Supreme Court has said very clearly. But you cannot start imputing oblique motives to court judgments or extraneous considerations for court judgments. And this will then tend for other people to think, okay, then this, we all know this order is not to be obeyed at all. We have scant respect for this. That would tend to then lead to disobedience of court orders, losing respect for the law. And therefore, this is the Constitution itself provides it can be done. So also defamation. We all know freedom of speech cannot go to the extent of Supreme Court judgments have held. What is most important is a person's reputation. If reputation is lost, everything is lost, as they say. And therefore, when there are criminal laws also, which make defamation as a criminal offense, of course, with certain restrictions and exceptions, which we will not go into for now. But recently, in the judgment of Subramaniam Swami's case, the question arose whether the acts which are amount to defamation, can they be criminalized? Can you be sent to jail for just defaming somebody? The Supreme Court said it is a reasonable restriction, and therefore the section in the IPC which made it an offense is reasonable, has to be there for other person's freedom to be protected. So these are some of the grounds on which freedom of speech and expression can be restricted. Then going on to the other freedoms which we have seen. So similarly, you will find Article 19.3, we have found the right to assemble peaceably without arms. But this again is subject to reasonable restrictions in the interest of sovereignty and integrity of India, public order. All of these grounds can be restricted. Now this is where you can now look back. We had the protests against the farm laws in Delhi, where the farmers organizations were saying, we are protesting on we have the right to protest, we have the right to assemble. But the Supreme Court said this is leading to public disorder. You cannot occupy the highways and prevent other people from having their freedom of movement. And therefore, the state is entitled to place restrictions on your right of assembly. It cannot be that you assemble wherever you want, whenever you want, in whatever numbers, and then prevent others from exercising their freedom. It has to be restricted with prior permissions, etc. And this is how, for example, the same thing could be invoked. Why could not all the fans of RCB assemble at the KSCA? It will lead to public disorder and chaos, and therefore laws are required to restrict these also. That's why you will find the reference to, did the KSCA take previous police permission? Did the RCB take police permission? Now you can relate all this. Why this is important is when you are seeing happenings in the daily life, you will not know where it is that is being traced back in the law. So this is just to give you awareness of where the Constitution speaks about this. Similarly, the reasonable restrictions to form associations or unions, again reasonable restrictions can be placed in the interest of sovereignty and integrity of India, public order, morality. Now, freedom restrictions to move freely, this also can be done in the interest of general public. So you would find, for example, sometimes when there are orders passed granting bail to a person, a restriction will be placed. You should not enter this territory because the victim or victim's family members are there and therefore you have to be kept out. All of this can be justified because there are reasonable restrictions being placed. Then similarly, restriction to carry on any occupation, trade or business in the interest of general public, reasonable restrictions can be placed. But the important word is reasonable restrictions. So again, every restriction which is placed, they are subject to challenges in courts. Courts have said, we need to see what is the mischief which the government is seeking to address by making a law and placing some restriction. Are there less restrictive ways in which the government can address the same issue? Then what is reasonable will be the least restrictive way. If there are different ways of achieving the same object, but you go for the most restrictive way, then the court will frown on that and say that is not a reasonable restriction. So the object of the legislation, what are the choices available in terms of how that object can be achieved by placing minimalist restrictions? These are all factors which will be examined by a court before deciding whether a restriction is reasonable or not. Now, Article 21, again a very important article, the right to life. So Article 21 guarantees the protection of life and personal liberty and says no person shall be deprived of his rights except according to procedure established by law. Now this article has received such a wide interpretation by the Supreme Court. Even though the article says only right to life, lot of these what are mentioned here are all brought in by the Supreme Court by way of interpretation to right to life. Right to life means it should be a meaningful life, not just a pedantic life. Therefore, right to life should be a healthy life. It should be therefore right to health care, right to education, right to livelihood. Now importantly, right to a safe environment, clean environment. All of these have been brought in within the concept of right to life. And this is where it has been interpreted to say this is available even against other individuals. This is how we found the Supreme Court in a case holding that we found hospitals or doctors not giving medical care to, let us say, either accident victims or other what they call as medico-legal cases, saying no, this is a medico-legal case. Unless police comes and first put some FIR, we will not touch this person at all. So the Supreme Court had to say no, this amounts to deprivation of his right to life. Therefore, you are duty bound, even doctors and hospitals are duty bound to save the life of the person, irrespective of other requirements. And therefore, even this duty was cast on doctors and hospitals to attend to the patients. Now, right to life, does it also include the right to die? Was one question which was asked. So the Supreme Court initially said, yes, right to life means you have a right to die also. You have a right not to live. But then the Supreme Court itself realized the dangers of this kind of extrapolation and said, no, you do not have a right to die. But then the question arose recently, I have a right to live with dignity. Don't I have a right to die with dignity? Let us say I am a terminally ill patient. It is destined that there is this disease which I am suffering from cannot be cured. And I am only being kept alive by medications which I am not wanting. It is a suffering for me. Don't I have the right then to say, if I am not actively at least, let us say, seizing my life, don't I have the right to say, I am not wanting this medication. Stop this medication in this circumstance. Then the Supreme Court had to deal with this issue and said, yes, there is a right to die with dignity. When you are of course, there are a lot of restrictions which I will not go into at this stage, but this is where you get the concept of what they call as a living will. That is, or what the Supreme Court terms it as advanced directives. That means when you are in a sound state of mind, you can choose to give directions that if I get into a stage where I am terminally ill and my faculties are not in my control and there is no way I can survive and I am being put through excruciating treatment, I should have the right to say, please stop this medication and treatment. So the Supreme Court evolved. This is all pursuant to this right to life, all brought under that interpretation that yes, there is a concept of right to die with dignity. So therefore, advanced directives. Of course, there are a lot of conditions put there about how this living will can be made, because you do not want this to be misused. You do not want, again, like how we find somebody perhaps unduly influencing some of their relatives to make a will to dispose of their property, to even make advanced directives about their departure from this world also. So therefore, the Supreme Court took care to say, till the Parliament legislates, we are giving these guidelines. There are a set of guidelines. So that just this, you need to be aware of these developments that I'm, each of these, if we get into details, it's whole sessions by itself. And therefore, I'm not getting into this at this point of time, but just for awareness that these are the developments which have taken place. Now, of course, Article 25 and 26, which need to be read together. Freedom of conscience and freedom to profess, practice, propagate religion. This is what is assured by the Constitution. But again, please see clause 2. Nothing in this article shall affect the operation of any existing law, prevent the state from making any law, regulating or restricting any economic, financial, political or other secular activity which may be associated with regular religious practice, providing for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Then the explanation itself says, wearing and carrying of kirpans shall be deemed to be included in the profession of Sikh religion. Then, of course, the reference to Hindus as to what all they include. Now, this is where it, in a way, ties up with the next point, which I'll be dealing with a bit later. But this clause 2 is where the state comes in when we ask questions. How is this government coming in the question of my religion? How can it regulate? The constitution says the state can regulate economic, financial, political, other secular activity which may be associated with religious practice. So what is prevented is the state cannot interfere with the essential practices of the religion. So the rituals, ceremonies of puja, let us say, the state cannot interfere. If this is how it has been customarily done, state cannot say, no, I will not do it. I will not allow, or I ask you to change it. But secular activity, what is secular? Something which is not religious, which is not an essential part of that religious practice. So, in the famous case of Sheshammal, which arose from the state of Madras, the Madras legislature passed the act stating that archakship shall no longer be hereditary. And therefore, it is not necessary that if there is an archak and if his possession falls vacant, only his son who is an archak should be appointed. Any other qualified person can be appointed as an archak. So that was challenged before the Supreme Court, stating that this is nothing but an interference with our freedom to practice our own religion. So the Supreme Court went into the question as to whether appointment of an archak is an essential religious practice or is it a secular practice. Then on analyzing historically, the court found a lot of temples where there used to be trustees. The trustees used to appoint the archaks, or what we call in North India as Sabahits or Shabites as they called. So therefore they said, therefore this is a secular activity. Other trustees were doing it, and therefore appointment of an archak by itself is a secular activity. Therefore the state is entitled to say, I can regulate it. Who is to be the archak can be a matter of religion. You may say this archak should be having these qualifications, this kind of experience, that's a different matter. But there is no right in religion that you must have hereditary archakship itself. It need not be. There could anybody else who is capable and qualified could be appointed as an archak. Therefore, Supreme Court said in Sheshammal's case, the appointment of an archak is something which is secular, and therefore state can make a law which says this appointment will not be hereditary, will be done by the government. So this is where now you can tie up whenever you are seeing news or when you come across questions as to how is the government interfering this. Similarly, economic, financial, so all your ticketing, your queues, all your other activities in temples, everything can be regulated by the state by virtue of this. That will not be considered as affecting your right to profess your religion, because only what is essential will be considered as a freedom which you need to have. Similarly, an issue arose, for example, the triple talaq. So when the issue arose as to whether triple talaq is constitutional or not, the Muslim community said triple talaq is an essential feature of our religion, and therefore you cannot say it's unconstitutional. But the Supreme Court examined it and said it is not an essential part of a religion that you should have a right to do talaq by saying 3 times, and the two at your will without any reason, and therefore that kind of a practice state can abolish, and therefore the Supreme Court interfered there and said triple talaq is unconstitutional. It was not considered an essential feature of the religion. So therefore, what is an essential feature of the religion will have to be examined in every case where the issue arises. So therefore, you will also find clause B then providing for social welfare and reform, throwing open the Hindu religious institutions of public character, all classes and sections of Hindus. Now along with this is the next article, which is also important. These two go together. Article 26, freedom to manage religious affairs. Again, subject to public order, morality, health. Every religious domination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. But please note, and again this is not, as we tend to think that as if only the minorities have some rights and the majority does not have rights. It is not correct. This, every religious denomination, whether it belongs to the majority or minority, have this right. Therefore, we need to have also clear some misconceptions we may generally have in our mind about how the constitution deals with majority and minority, as they say. We will deal with the article on minorities also. But this deals with every religious denomination, but again, subject to public order, morality and health. So that's why you would find where this Devadasi system was prevalent, the Supreme Court said no, that is something which the state is entitled to abolish because it is provided for under Article 25-26. And your right to establish and maintain institutions, manage your own affairs, acquire movable and new property, administrative property is all subject to public order, morality and health. And this is where you will find that when there is misappropriation of funds, public funds, where what devotees contribute are not being used properly, it is being used for private purposes, that is when the state steps in and says, okay, then there has to be a regulation of how these funds are going to be used. Now, Article 30 is the next article which deals with minorities. So this was a special protection for minorities. All minorities, whether based on religion or language, because as you know, we were divided into states based on language, and therefore there could have been linguistic minorities in every state when this division took place. So therefore, this was contemplated by the constitution also. They will have the right to establish and administer educational institutions of their choice. And therefore, you will find the minority educational institutions like linguistic or religious minorities having the right to take admissions. But again, the Supreme Court has stepped in and said state can control. It should not be without merit. It should be on the basis of merit. And it cannot be that you just appoint anybody of your choice without the necessary qualifications. So somewhere, at least in terms of qualifications, let us say there is a minority institution. Can it appoint teachers who are not qualified at all to teach particular subjects? These are all subject to regulation, and therefore that will not be a violation of their right under Article 30. And I would say perhaps the most important of all, Article 32, because this is an article which guarantees that you have a right to go to the Supreme Court if any of your other fundamental rights are violated. So a fundamental right is created in every citizen to have a remedy in the Supreme Court for violation of your other fundamental rights. And then the Supreme Court has got various powers. I will not get into the technicality of these, to quash laws, quash decisions, to see that tribunals do not cross their jurisdiction, even elections, if somebody is holding public offices, to question how they are holding offices if they are not qualified for this purpose. Now, another article, which is the Article 300A, this was earlier in the form of Article 19(1)(f), which is now not there. This was a right to property. So, when the socialist reform started in the early 50s, this right to property being given as a fundamental right was considered by the parliament to be an impediment in so many land reform laws. So, therefore, they took out the by way of an amendment, but it is still recognized under Article 300A by saying it's a constitutional right, though not a fundamental right. Therefore, your right to property cannot be taken away except as per a procedure established by law. And Supreme Court has interpreted to say that has to be reasonable, that should not be going beyond what is necessary. Various restrictions are now placed, and virtually it is brought back in a form of fundamental right, if not directly as a fundamental right, because the Supreme Court now says if you do not have property, you may not be able to earn your livelihood. If you do not have livelihood, your right to life under Article 21 is affected, and therefore a deprivation of property could also have a right on your right to life and livelihood. So therefore, there are interpretative tools which are used by the courts to give protection to citizens. Now, coming to the next section, which is where we are coming to government intervention in religious matters. So, if I may say so, it is not that it is only after the constitution that the government started interfering in religious matters. That's a misnomer. It is not as if it's been done only in the last 50 years. That's also not correct. So, let us understand, if we see historically and go through the court decisions, disputes have been the cause for the state to step in. When you are not in a position to manage your own affairs of an institution internally, resolve disputes, and when the disputes go out of the bounds, naturally people start looking for somebody else to resolve their disputes. This has started right in the times of even British Raj. We see decisions even from 1700s, 1800s, where there have been disputes in relation to temples, and because the British Raj was then governing, either they were collectors or in whatever authority, they used to go to them and they used to then pass orders, because otherwise these disputes tended to lead to public disorder, because naturally religion is something which is held very in great sentiment by the citizens, and something which affects them, they then try to take it out. It goes on to the streets also, and then naturally leads to public disorder. Then naturally, to maintain order, somebody needs to step in. So if you are not in a position to regulate your own affairs and you go to somebody else, then you can't blame him then for stepping in and say, no, why are you now stepping in? So historically this has gone on, where we have not been able to manage our disputes. Even prior to the constitution itself being enacted, it was, as I said, British Raj. Then when they brought in the court system, we see that there are a lot of cases which English courts have decided. Even now, some of the judgments which we follow are English judgments of 1800s, 1900s, where English, therefore courts stepped in, but courts also kept on expressing. In fact, the civil code CPC section 9 says, disputes of a civil nature is what a civil court can inquire. So the court started getting into the question, are we at all empowered to go into religious disputes? We don't know anything about the religion. What is right, what is wrong? How do we get into pure, whether he is entitled to first tirtham or that person is entitled to second tirtham, or which honor? How do we get into it? We are not here to deal with civil disputes. But then these rites in temples were always associated with some emoluments. So therefore there is an element of property also which was involved. Emolument, it may be money. Money is also considered as property. And therefore when the disputes became attached to property or emoluments, then naturally civil courts had jurisdiction, and therefore people start going to court saying, okay, even if it is about some maryada which I have to get, let us say, if I am deprived of it, that comes with a particular emolument, and that emolument I am being deprived, therefore I am going to civil court now, please look into this and remedy the situation. So therefore courts were also dragged into this picture. Courts found that they were not able to manage with all the religious issues, and therefore, in fact, in Karnataka, for example, in Mysore state, we had a Religious Institutions Act of 1927, which was made by the Maharaja at that point of time. So therefore, it is not that the constitution has allowed the government to take over temples and institutions. So somewhere we may have to question ourselves, why have we not been able to regulate our own affairs in a manner that we can resolve internally rather than going out before we raise these questions. And therefore we had acts right from 1800s, 1900s, which have been regulating temples historically. Now in Karnataka, I will deal, every state has got one act or the other which deals with Hindu religious institutions. Now in Karnataka, we have the Karnataka Hindu Religious Institutions Charitable Act of 1997. In fact, this was thought to be a more, let us say, progressive kind of legislation, because there was a committee which was headed by former Chief Justice Ramanujaya, who was an authority on temple matters and affairs. So therefore, they took his inputs as to how is it that the government should start regulating these institutions, and therefore we had this. So there is a, while in other statutes which you find in different states, it is just the government which is regulating straight away the religious institutions. Here the government felt we could have a slightly different method. So they had something called as the Rajya Dharmika Parishad, which is there under the 1997 Act. Now this becomes a dispute resolution authority for religious practices, customs and traditions to decide whether a temple is public, private, whether it belongs to a particular denomination or not. What is the nature of the institution? Is it a purely religious institution or is it a composite institution? Determining hereditary trusteeship. Is it a trusteeship hereditary? Who then succeeds if there is a dispute? All of these. So it has also got administrative powers to constitute management committees for institutions with income above 25 lakhs, that is temples. So they have contemplated what is called as a committee of management for every temple. And it will act as an appellate authority also. This is at a state level. For every district there will be a Zilla Dharmika Parishad, and appeals from the Dharmika Parishad, Zilla Dharmika Parishad will come to the Rajya Dharmika Parishad, and then it will constitute a Nyayadhikarana. That means where there is a legal dispute, it will have a legal body to deal with it. In fact, district judge is supposed to be one of the members of that, which we will find in the next slide. And who are the members of this Rajya Dharmika Parishad? Of course, the minister in charge of Hindu Religious and Charitable Endowments will be a member. He is the chairman. Secretary of the government, vice chairman. The commissioner of Hindu Religious Charitable Endowments, he will be the secretary. There will be members nominated by the government for a period of 4 years, and then you will find one retired district judge, one Agama scholar, one Vedic scholar, one person belonging to SC/ST, one person belonging to backward classes, one woman and two others. So they have tried to broad base the composition. Earlier, in the earlier Act of 1927, you would not find such a provision. So there must be persons who are actually interested in the institution also who are there. Therefore, they have brought in even the Agama scholar, Vedic scholar, etc. You would find similarly provisions in the Zilla Dharmika Parishad. So these will be in charge of the temples which have annual income below 25 lakhs, and they will be the ones who will then be monitoring the functioning of these temples, and they can also resolve disputes through a Nyayadhikarana. And then you can have a look at the members of the Zilla Dharmika Parishad in the next slide. The deputy commissioner of the concerned district, he will be the chairman. The assistant commissioner of that district will be the ex officio secretary. Then again, members will be nominated by the government for a period of 4 years. Then one retired judicial officer, not below the cadre of civil judge senior division, one Agama Pandit, Vedic scholar, scheduled caste, scheduled tribe, one woman, one person from backward classes, three others. So even the Zilla Dharmika Parishad is contemplated to be off. The real issue where we find practically is the government starts considering these. You see now, for example, the power to nominate, members to be nominated. This is where the issue arises mostly. Then you choose, like whenever a party comes to power, it says, okay, where can I start giving positions of power to my party leaders and those who have helped me win the elections. So then, yes, here is a Dharmika Parishad. Okay, I'll nominate 4 of my people there. You will get some benefits there in terms of salary, perquisites, an office to function from, whatever it is. Then of course, because now then they are also overseeing the functioning of the temple, corruption then comes into the picture. So this will happen once there is government nomination. But it is not that, I must also point out, it is not that the corruption is limited to only government nominees. What we hear now is corruption is on the rise even in private organizations. So perhaps the answer lies not just in making laws, but in reforming society and in reviving Sanatana Dharma in its form, where people are reminded of their duties, whether that they should not be looking at materialistic returns and benefits, instilling that, which is what Jeeyar Swami is trying to do through a series of discourses, outreach to all the population, to say this is the way you have to live, the Sattvic way of living. Once that gets infused into society, only from then will people then who are also of Sattvic nature come into all these bodies. Without that reformation in society in this manner, you cannot expect corruption-free organizations or government. And therefore, you would find, though the legislation has tried to broad-base these institutions, it is still not bringing the result. Now, the committee of management, this is the body at the temple level, so which manages the affairs. So you have a 3-tier structure. One is a Zilla Dharmika Parishad, Raj Dharmika Parishad, but at the ground level, it is this committee of management. Again, the government has tried to see to broad-base it, because please see the members of this. In the case of a temple, Pradhan Archak or the Archak, 1 member of scheduled caste, scheduled tribes, 2 women, 1 from among the persons living in the locality where the institution is situated, and then he must have faith in God. He has attained the age of 25 years. He possesses good conduct and reputation and commands respect in the locality in which the institution is situated. And these are the requirements which are made. So there is an attempt made to try to involve the locals, but that is still not worked on the ground as we see it. Now, going to the next slide, this is another important, now I must also point out, mutts traditionally have not been regulated by the government, because they have not felt the necessity to do so. And the reason is also not far to see, because insofar as a mutt is concerned, there cannot be a dispute, at least generally, because everybody has to listen to the Matadipati. Whatever the Matadipati says is final, and therefore he is the one. And fortunately, by and large, most of the mutts, they have been following the same principles of our Sanatana Dharma in administering them, and therefore there has been no need felt for the government also to interfere. There have been occasions. The earlier act also did provide for an intervention if required, but not the same level as the temples which have been regulated. But then the devotees felt that this is too much of a interference with religious affairs, and the present act does not provide for much to be regulated. But why I'm pointing this out is, this is of the Civil Procedure Code, and this has been there from 1908. Now, when issues have risen regarding mutts also, issues regarding misuse of property, issues regarding succession to the mutt, these have all been issues which have arisen. When disputes arise, if the government is not regulating, where do they go? They go back to civil court. But civil courts, do they have powers at all to deal with mutts? Now this is where, by an interpretative exercise, courts have held. Section 92, if you see, it says, any alleged breach of any express or constructive trust created for public purposes of a charitable or religious nature. This deals with the religious or charitable trust, which we all know. And therefore, if religious and charitable trust, if there is any issue, you can always go to the courts to replace the trustees or to frame a scheme. But the courts interpreted a religious trust to include a temple, to include a mutt. Because they went into the objects of what is a temple for, what is a mutt for. And they said, mutt is an institution. The Mathadhipati is the head of the institution, but mutt is a separate institution by itself. That institution is meant for the benefit of the community to which that mutt belongs, and therefore that is nothing but in trust. Therefore the property has to be in trust, held in trust for the benefit of the community for which the temple or the mutt exists. And therefore if there is a breach of that trust, then we can frame schemes. It is in pursuance of this power that you would find a lot of temples also, there have been schemes framed by the courts under the section 92 of the Code of Civil Procedure, which even today govern some of the temples. In fact, in Tamil Nadu, there are a lot of temples where, famous temples, in the Kanchipuram temple or Srirangam temple also, there are schemes framed by the court which govern. Now, where did the court get the power to frame the scheme? It is under section 92 of the Code of Civil Procedure. So, this is just to give you a broad understanding of where the court, the government gets the power to intervene in religious affairs. And then, subject to availability of time, I will just quickly go through the other portions of the other topics which are there. Now, dealing with succession and inheritance. Now, section 8 of the Hindu Succession Act, this gives the rules for intestate. Intestate succession means where you do not make a will. Without making a will, if a person expires, who succeeds to him? It gives out the order. So, insofar as a male Hindu is concerned, you would find class 1, that is, they will succeed immediately. Son, daughter, widow and mother. Very importantly, you would notice a father is not included here. So therefore, but a mother is included. So therefore, if a male Hindu dies intestate without leaving a will, his son, daughter, widow and the mother will equally be entitled to a share. The father comes only later. So if you go to the next class, that is class 2 heirs, that is where you would get father. If all of those, that is, father will come there only if those in class 1 are not there. If there is no son, no daughter, no widow, no mother, then only father comes. If father is also not there, then other relatives, brother and sister come in picture here. So there are other, of course, grandchildren are provided, then brother and sister. It is in this order that succession happens to a male Hindu. Now, insofar as a female Hindu is concerned, if we can just go to the next slide, sections 15 and 16, they set out the rule of succession for a female Hindu. Now, here you would find sons, daughters and the husband. So, here neither mother comes nor father comes. It is the sons and daughters and the husband. And then, if none of them are there, then heirs of the husband, then mother and father, then heirs of the father, heirs of the mother. So, of course, it is rare to find cases where none of them in the first class themselves are there. Usually, they will have sons, daughters or husband, or otherwise it will go to the heirs of the husband. It is in this order that succession happens. Then, an important aspect which needs to be pointed out is, in the context of joint family property, everybody would have heard, now daughters have the same rights. It is not that daughters did not have a rights all this while. Daughters had right from the Hindu Succession Act of 1956. But when it came to joint family property, the law, ancient Hindu law was, it is only the sons who would be co-partners or who would be having the right to have a share in a joint family property. Now in 2005, the parliament made an amendment to say, no, even a daughter would have the same right by birth. So you must have a understanding of what is joint family property, what is the distinction between this and other properties. Joint family property or ancestral property is one which a person inherits from his ancestors, usually the male lineal ascendants. Now, in that, once it is joint family property, a male used to have a right in it by birth. That means if my father has joint family property, if he has got, let us say, property which he has inherited from his father, the moment I am born, I have a right in it. I need not wait for my father's lifetime to get over to have my right. My right is in by birth. And therefore, I have a share straight away in by birth. That is the concept of joint family property. That right was there only to a son earlier. Now, from the 2005 amendment, the parliament has made it clear, even a daughter gets a right in joint family property by birth. Now, here is one nuance which most would not know, which I think you should have in mind if you come across this situation. Now, after the 1956 Act, if a person has got his own property, self-acquired property, it's not ancestral, let us say with his own income he has acquired some property and he has died, then you have seen if it is a male Hindu, his sons, daughters or wife will have a share in it after his lifetime. Now the question arises, in the hands of that son, he has not acquired it. It has come from his father. So does his son, that is the grandson, get a right in it by birth? Because will it be considered as joint family property? The Supreme Court has said no. After 1956, whatever, now if you just go back 2 slides, just kindly go back to 2 slides before that. To go back 1 slide, we have, yes, no, prior to this. Before this. Yes. So you see section 8 says this is how if a male Hindu dies, inheritance will take place like this to son, daughter, widow, mother. The Supreme Court said, look, this does not say a son's son will also get a right in it. It only says son. Therefore, if a self-acquired property, if a person has self-acquired property and he has died after 1956, only his son, daughter or widow will have a right. That son's son or the daughter's daughter or children will not have a right in it by birth. So therefore, that will still be as if it is his self-acquired property, even though he has actually not earned it, he has got it from his parents. So now coming back to the 2005 amendment, the 2005 amendment does not change this. If something has already been joint family property earlier, and then a daughter is born, the daughter also gets a right in it by birth. The only difference the parliament said is, okay, if any transactions have taken place before this act came into force, they have given a cut-off date of December 2004. Let us say some sales have already taken place or some partitions have already taken place. What happens? Will they all be disturbed by it? The parliament said it will not be disturbed to that extent that they have taken place earlier. Therefore, this is what is, the next slide will give you the meaning of joint family property. The joint Hindu family consists of lineal descendants from a common ancestor, including sons, grandsons, great-grandsons. 3, 4 generations, up to 4 generations will be part of the Hindu joint family property, and their wives and unmarried daughters. While they will be part of the joint family, co-parcenary is a narrower concept which comprised till the 2005 amendment of only the males. Now after the 2005 amendment, it will be the daughters also who will be part of the co-parcenary, and then the daughter's son, daughter's daughter also will become co-parceners by birth, in which case they will have a right to seek partition during their lifetime. The difference is this: if it is self-acquired property, your children don't have a right to open their mouth and ask anybody a share till your lifetime. It is entirely your choice whether you want to give them or not. Nobody has. People think as if they are obliged if they make some properties that they need to give within their lifetime. If their son or daughter comes and asks for their share, there is absolutely no such requirement. The right is there only insofar as joint family property is concerned, which is ancestral property, as it says, where a son or daughter can say, I have a right in it by birth, please give me my share, I want to go out and do things. It is only to that the share in birth will apply. Otherwise, they don't have a right by birth. And this is where we come to the last topic, which is on wills. So, any person has a right to dispose of his property by way of a will, and this will, let me make it clear just for because it's an awareness program, it need not be on stamp paper, it need not be registered, it can be in your own handwriting also. In fact, sometimes when wills are made by a person in his own handwriting, courts give more importance to that because it means a person has expressed, we can see it in his handwriting, it means there is absence of any fraud or undue influence or coercion or these kind of stuff, and it need not be registered. It is not mandatory to register it. Now will, you can make a will to whomever you choose. You can, I would say, will it to the mutt also, for all religious purposes. You are absolutely free to do so. There is no restriction. Even if there is joint family property, to the extent that you have a share in it, your share can be willed. That is made clear by the law. Therefore, whatever share a person, a son or daughter has by birth, that you cannot naturally affect in joint family property. But your own share, you can make a will. And this indicates your intention. Now, the reason, normally, if people, when does the necessity to make a will arise? If they feel that there is to be avoided confusion after a person's lifetime, avoid disputes between the legal heirs, how the property is to be divided. That is when people tend to say, let us make a will. Registration is preferable, though it is not mandatory. I would say it is preferable because the Supreme Court has now said in a recent judgment, if it is registered, now you have a facility where your photograph is also captured when a document is registered. There is that much more authenticity to that will. Yes, it must be done. Nobody could have forced you or taken your signature by force in your house or unduly influenced you. You have after all taken the trouble to go to a sub-registrar's office. He has also verified whether it is your signature. Therefore, there is some presumption, a general presumption that yes, it may have been done out of free mind, though that is not a guarantee. Merely because you have registered a will does not mean it cannot be challenged. It can still be challenged. There could be the person who sets up a will has to prove to the court, because usually the question of a will arises when the person who wrote it is no longer there to say. Therefore, in his absence only the question arises. Therefore, the court has to be convinced that yes, a person has done it with his free will and volition. There, one important requirement is to have two attesting witnesses. So, there should be two attesting witnesses to a will, otherwise that will be invalid. Attesting witnesses means they must have seen you sign the will in your presence, and they must also sign in your presence saying, yes, I am signing to acknowledge that this person signed this will in my presence, and I have also signed my signature in his presence. Now, will, if you are leaving it merely to your heirs to take care as per the natural law of succession, there is no need to make a will. But if you feel there could be confusion, or you want to dispose of your property in a particular way, where you want to give, let us say, some properties for a charitable purpose, some properties you may want to leave to your children, then you should make a will, and then preferably register it so that the authenticity will be there to those wills. Otherwise, if you feel that there is no prospect of any confusion, you don't have too many properties, and you don't intend to give to anybody other than your own children or your wife, yes, sometimes people feel, especially if they have, let us say the spouse, especially, be it the husband or be it the wife, if they feel, I'm not so sure how my spouse will be treated after my demise. So I do not want my spouse to be dependent on somebody, or if I'm in a house, I do not want some dispute to arise where there is a partition of my house itself and my spouse has to be then forced to move out somewhere. Then you may consider making a will to leave this entirely to the spouse. Sometimes people also see, I want it to go to my spouse only for his or her lifetime, so that he or she has a roof on their head. But thereafter I want it to go to my children only. Then there is something called as a life interest which you can create by way of a will, where you will say, I will create a life interest in favor of my wife or husband, so that they will have a right to reside and to earn any rents or income that is coming from that. But they will not have the power to sell or mortgage it, etc. Then after the lifetime of the spouse, it goes to the children. And therefore, in such circumstances, a will can be made. It can be made without much formality, but if it is registered, it is better, so that the whole object of making a will, there should be no dispute, there is no confusion, is always dealt with better. Again, it is better to keep a will as simple as possible. A will can always be altered, revoked. It is not that if a will is made once, you cannot change it. You can always change it till the end of your lifetime. You can cancel it. You can do however you want. This is the object of a will. I'm sorry for having taken more time than granted. Again, I'm grateful for all of you for having attended this session. My grateful thanks to His Holiness Jeeyar Swami for having given this opportunity. If you have any doubts, you can always raise them. I only hope that your time here has been well spent, and there has been some information at least which you feel will help you understand the situation. I could not, in fact, deal with consumer protection because I've already exceeded the time. It's already close to 8:30 and all of you should be waiting to get home.
Srimathe Ramanujaya Namaha. One important piece of information that we missed in the beginning while introducing Shyam Mama was he's not only a very accomplished lawyer, advocate, he's also a great social service. So I think his dedication and his interest in the entire field of social service, helping people, has been very, very well received by everybody, I think recognized by everybody. He's also very, very active with the Kinchitkaram Trust as well of Sri Velukudi Swami. So I think it's so important, and it is so fulfilling to have him here with us today. And we want to open the floor to any questions. We are short of time, but a few questions from the people gathered here. Anybody?
ಸಾಮಾನ್ಯ ನಾಗರಿಕನಾಗಿ ಲಿಟಿಗೆಂಟ್ ಅಂತ ತಿಳ್ಕೊಂಡು ಕೋರ್ಟ್ ಅಂದರೆ ಅಸಹ್ಯ ಆಗ್ತದೆ ನಮಗೆ. ತುಂಬ ಡಿಲೇ. ನಾ ಸತ್ರು, ನನ್ನ ಮಗ ಸತ್ರು, ನಮ್ಮ ಮೊಮ್ಮಗನ ಇದಕ್ಕೆ ಬರ್ತಾಯಿದೆ. ಹೀಗಿದ್ದಾಗ ಸುಧಾರಣೆ, ಜುಡಿಷಿಯಲ್ ರಿಫಾರ್ಮ್ಸ್ ಎಷ್ಟು ಮಟ್ಟಿಗೆ? ಇವಾಗ ಮೊನ್ನೆ CRPC, CPC ಎಲ್ಲ ಅಮೆಂಡ್ ಆಯಿತು. ಅಮೆಂಡ್ ಆದಮೇಲೆ ಅದ್ರ ಎಫೆಕ್ಟ್ ಏನು, ಅದ್ರ ರಿಸಲ್ಟ್ ಏನು? BNSS ಅಂತ ಬಂತು, ಭಾರತೀಯ ನಾಗರಿಕ ಸುರಕ್ಷಾ ಸಂಹಿತ, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಸಂಹಿತ ಅವೆಲ್ಲ ಬಂತು. ಅದರಲ್ಲಿ ಏನಾದ್ರು ಸ್ವಲ್ಪ ಸುಧಾರಣೆ ಆಗಿ ನೆನ್ನೆ ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣ ಜಡ್ಜ್ಮೆಂಟ್, ಜುಡಿಷಿಯಲ್ ಕ್ವಿಕ್ ಆಕ್ಷನ್ ವಿತಿನ್ ಎ ಸ್ಪ್ಯಾನ್ ಆಫ್ 1 year ರಿಸಲ್ಟ್ ಬಂತು. ಆ ಥರ CPCಲಿ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೊಡಲಿ ಬರ್ತಾ ಇಲ್ಲ. ಸುಮ್ಮನೆ ರಬ್ಬರ್ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದೆ. ಅದು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಆಗಿರ್ಬೋದು, ಅಥವಾ ಇನ್ಯಾವುದಾದ್ರು ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿರ್ಬೋದು, ಅಥವಾ ಫ್ಯಾಮಿಲಿ ಇದರಲ್ಲಿ ಡೈವರ್ಸ್ ಕೇಸ್ ಆ ಥರ ಆಗಿರ್ಬೋದು. ಅದಕ್ಕೆ ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಹೈಲೈಟ್ ಇದ್ರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಪರೀಕ್ಷೆ.
There have been developments even on the civil court side. The Parliament has come out with something called as the Commercial Courts Act. So commercial courts have been set up for commercial transactions, commercial disputes, which will deal with only a particular category of disputes. Their very strict timelines have been laid down for how to go about disposing the matter. But I would say these are some measures, and we are in fact seeing in Bangalore the commercial courts have been doing reasonably well. We are seeing an improvement in the timelines. When a person files a case, it is called as a suit or a plaint. Then notice goes to the other side. Now earlier we used to see this process of serving notice on the other side itself used to take years. Now the courts have legislations have evolved to say you can serve notice even by email, by courier. So therefore that process has got reduced quite a bit. Then earlier the timelines for filing his version or his written statement, as we say, used to take its own time. But now the legislation has been amended to say you have to file if a person is a defendant. Let us say he is the opposite party in a case. He cannot take his own sweet time to file his statement. He has to do so within a particular time limit, 90 days. It cannot be extended beyond that. If it is extended, then if he does not file it, he loses his right to file his defense. That defense he is not allowed to then thereafter contest the matter. So therefore there are measures like this taken. But we must understand that our country is vast. We are the most populous nation in the world. And none of you vote if the government makes good courts and judges. You vote if you get good ration, good electricity, good water, good transport. Spending on judiciary is not a vote factor at all. Therefore, it is not priority for the government. If you see the ratio of judges per population when compared to other countries, we are at the least. We don't pay judges well. We don't have number of judges. We want lawyers to give up their practice which is paying and sacrifice by becoming a judge and do their jobs. How do you expect this? There are various, it's not just procedure. When you are talking about trials, some cases like what has happened recently, it happens with some those which attract media attention. It happens very quickly. But not every case is worthy of media attention. It should not be that only media worthy attention cases get decided quickly. But for that, several reforms have to be made from very, very different angles. There has to be proper training to lawyers. Just for the sake, you cannot just increase the number of judges. You would have competent judges, for which, if you just have number of law colleges just churning out lawyers, it is not sufficient. You have to give them training, for which you have to have training institutes, which train them to become judges. There are a lot of things to be done. It is being done piecemeal, therefore, but we are seeing definitely arbitration is catching up. Arbitration, in fact, is a mode of a faster resolution, where at the outset itself you make a clause in an agreement that if we have any disputes, we will get settled by arbitration. So arbitration is a process where it does not go to a court, but it goes to a third party who is usually a retired judge, or it could even go to a lawyer. You could have your own arbitrator whom both of you are confident that yes, we will go to this person to resolve disputes. But that dispute cannot again be resolved by as per his whim and fancy. He has to resolve as per law. So therefore arbitration also is as per law itself, except it is not in courts. It is by a process which you have agreed upon beforehand itself. There will be an arbitrator. The same procedures will be followed, except without all the technicalities. Therefore it proceeds faster. The law has provided that arbitration should also get over in a maximum period of 1 year and extendable by another 6 months. We are seeing most of the arbitrations do get over in 1.5 to 2 years. But then there is a process of again challenge to those awards, because whenever there is a decision, every person who is dissatisfied will want to have one recourse to some, if he feels that he has been wronged, to a challenge. Again, that challenge comes back to courts, and there again you are stuck with this court process. So that is where we are being held up. But there are number of measures being taken. It cannot be seen to a person on the ground, because lot of factors have to be addressed, including the number of judges, number of courts, and therefore you are not yet seeing the result on the ground. Mediation is different, arbitration is different. Arbitration is an adjudication. That means somebody decides, you are right, he is wrong. Mediation is where a third person tries to bring both parties to settle. He is not going to take a decision and say, yes, you are right or wrong, or he is not going to dictate, you do as per this is my decision. No. That is, mediation is a third party intervenes to try to bring parties to a settlement. That mediated agreement also becomes enforceable, it is valid. But it is only trying to bring parties to a settlement. If that is not possible, then you have to resort to some dispute resolution method. One of the alternative methods is arbitration, where it is not through the court process.
Srimathe Ramanujaya. My question is about the general power of attorney. A person has 2-3 properties and he gives a general GPA for me to sell all these properties, sell or purchase or do mortgage. And after some time, he comes back, or he wants to sell one of them on his own. Is it possible for him to sell directly? Yes. Should he cancel the GPA?
Yes. So you see, a GPA is not a valid mode of transferring rights. That is very clear. Everybody should be clear about it, because even the Supreme Court has noticed, not only in Bangalore, in several places, people have been dealing with properties based on GPAs. The law has been clear right from the beginning. If you need to transfer rights in property, it should be by way of a registered document conveying title. A power of attorney is only appointing an agent. Therefore, by appointment of an agent, you are not transferring property. So, if a person has given a GPA to you to sell properties, it does not mean he has only appointed an agent. He retains the right to deal with it on his own, unless he has transferred some right in your favor, which has to be by way of a conveyance, by way of a registered document. If that is not done, he is always...
No, it is a registered document. Well, whether
it may be registered, but the terms should convey right. A GPA will only say, I am appointing so-and-so as my attorney or agent to do so-and-so acts. The GPA itself may be registered, but that wording of the document does not show any conveyance of title. It is only appointing an agent. Therefore, unless there is conveyance of title, which means something is created already which he cannot touch, then he cannot deal with it. But if he has just given a GPA, he retains powers to deal with it, even if it is registered.
Thank you.
In fact, I wanted to address one more aspect about dealing with properties. But since there was no time, I had to delete that, because one of the frequent questions which are asked is, people are dealing with properties. The Supreme Court has now recently in December 2024 said, a building without occupation certificate, do not give it electricity connection, no water connection. So please avoid taking buildings which do not have an occupation certificate. That is one general advice which I can give you. You are taking a risk. People have in fact told me that my own relatives have also told that we come and ask you, we will never make a property in Bangalore. But there are risks associated. So then you have to go with your eyes open that you are taking a risk. And for your bad luck, people will say, this property is not built as per sanctioned plan. Do I buy it? Any day if corporation comes and issues a notice of demolition, what will you do? People ask me, sir, but 95% of buildings in Bangalore are not as per plan, sir. If your falls in 5%, how do I assure it? It is your luck. Therefore, always try to be careful when dealing with property. Always look for approved layouts. That's the other thing when we are talking about apartments, when it comes to sites, please look at approved, BDA approved or BMRD approved layout sketches. The reason is, we have seen number of frauds taking place. If it is an unapproved layout, there is no guarantee that the plan or sketch which he is showing you is the same plan which he is showing to somebody else. He may prepare one sketch, show that yours is site number, let us say 10, and sell it to you. Same, he will prepare another sketch, show that site number 10 as site number 15 to somebody else and sell it. And then there will be a clash on the ground. Therefore, please look at approved layouts only if you are looking at sites. It will cost more. So you have to then take a call. Do you want to spend more, or do you want to have the risk of litigation? Do you want to have a clean title? Please look at occupation certificates, buildings with occupation certificates. Please look at sites with approved layout plans only. And then you have to, please do not, the other point, one point with Jeeyar Swami's permission, I am taking 5 minutes only, because this is again one frequent question which I come across. But sir, bank has approved loan, sir, against this property. Banks do not look at title properly at all. They are concerned with their loan and the repayment of their loan. They are not looking at owning the property. Therefore, just because a banker has approved some loan for some property, that is no assurance. I would request you, of course this is to help my profession also, please go to a lawyer. Even if it means paying some fees. It's a huge investment you are making for your lifetime with your savings. Please make sure a proper check is done. Do not just try to do a shortcut method and say, okay, that person has purchased the neighbor property, this person has purchased that property, he has referred it, and bank has approved, therefore I will not check any documents, everything is okay. Then you are taking a risk, and if it could be even couple of years down the line, 5 years down the line, 10 years down the line, where you may have taken a site, built a house, and suddenly you would find some claim being made by somebody else. To avoid risks, please, I would suggest, better take legal advice, have your papers shown to a lawyer, check whether these are, for a basic understanding, look at PDA approved sites, don't look at, now all the authorities have put up websites. These are the unapproved layouts, these are the unauthorized layouts. Please go check whether your layout or building is coming within that, whether there is an occupation certificate. These are all some basic checks. Please look at the encumbrance certificate to check whether any transaction has already been done. Whether the original documents of title are with the person, that's another important indication as to whether he has already transacted with somebody or not. And coming back to the point about joint family property, sometimes that's why lawyers insist, not because what is joint family property? If a person has purchased a property in his name, but if he has used funds of a joint family, then also it can be joint family property. It may be in a person's name, because no tail deed will say so and so HUF. It will never say that. It will say an individual, usually the eldest male member of that family, his name will be there. But that is no assurance that it has not been bought out of joint family funds. And then you will have to then verify and make sure even all their major children who are joining in the sale, so that tomorrow nobody claims, no, this is joint family property. My father or the Karta sold it off without my knowledge. He did it for some XYZ purpose. I did not get any benefit. These are all pitfalls which you need to avoid. Therefore, before transacting with property, I would advise all of you to consult a lawyer, even if it means paying some fees, because it secures at least your investment. Yes, that has been implemented. Yes. It's a central amendment which has been implemented in Karnataka also. Commercial Courts Act is a separate act itself. It has already come into force in 2015. We are having commercial courts in every district. Commercial courts are there. Again, grateful to His Holiness Jeeyar Swami for having given this opportunity. Thank you all.
I'm sure all of you will agree this was a very insightful session. It was very kind of Shyam Mama to share this information with us. I would request Chaitra to come and please present a vote of thanks.
Srimathe Ramanujaya Namaha. Namaskarams to everyone. Humble pranams to our revered Swami for blessing this legal awareness program and always guiding us with compassion and clarity. A heartfelt thanks to Srinivasa Raghavan Mama, Senior Advocate, for sharing your valuable time and deep legal insights with us today. Your words were truly enlightening and have made the subject of law accessible and meaningful to all present here. We also thank the RTT team. We also thank the RTT team for efficiently organizing the event and the all devotees here, participants, for your presence and involvement. May this awareness grow within and help build a more informed and responsible community. Now I request Srinivasa Raghavan Mama to receive Srimutt honors from Jeeyar Swami. Srimathe Ramanujaya Namaha.